Good afternoon, and thank you for joining us today for Navigating the New OFCCP Regulations on Affirmative Action Obligations. Make sure your organization is ready. I'm Patty Sager, Business Development Manager at Williams-Mullen. Let me introduce our webinar panelists today, all of whom are part of our Labor and Employment Practice Group. We have Sara Rafal, Laura Windsor, Mary Pivec, Lynn Jacob, and Randy Thompson. In the next 60 minutes, the panel will share information regarding changes to the OFCCP regulations and considerations for preparing your organization accordingly. We will conclude with a questions and answer session. On that note, we have some housekeeping detail for you. We encourage you to ask questions throughout the program using the chat feature on the right-hand corner of your screen. You may post questions to WM Questions, and we will answer them at the end of our presentation. Lastly, please place any cell phones away from your landlines to minimize audio interference, and please mute your phones. So let's begin, and I'll turn it over to Sara Rafal in our Virginia Beach office.
Good afternoon, everyone. Thanks for joining in with us today. I hope that will help clear up any confusion that you all have about the new regulations. What we've seen since President Obama's taken office is an increased strength of the OFCCP. There's been a 35% increase in the OFCCP staff. And what they've done with that is what we've seen as a result of that increased staff is we're seeing more in-depth audits. And those audits, we're seeing increased scrutiny during those audits. You're getting more follow-up questions relating to the data. They're taking longer amounts of time, the length of the audit, and the auditors being more active in their requests. We're seeing when you have facilities, when you have companies with multiple facilities, whereas in the past they might have only audited one facility, we're seeing a lot of audits where multiple facilities of the same company, the same contractor, are getting audited. We're also seeing more companies getting audited. So while the audits are more in depth for the people who get chosen, more people are actually getting audited. And we're seeing a lot more of the smaller companies, which previously weren't getting audited quite as frequently. Companies that are just over the threshold of coming under the OFCCP's jurisdiction are getting audited. We're seeing some interesting things happening during the audits, other than just the increased scrutiny. I've had one where there were reverse discrimination issues that they brought up on the placement with the minorities. We're seeing more aggressive requests from the auditors in terms of asking for more information, and they're more aggressive in finding violations. I believe that one of our attorneys has already had auditors requesting information under the new regulations that we're talking about today, even though they're not in effect yet, even though a company would have no obligation to have this information, they're already starting to request it. One thing that we anticipated coming into the Obama administration is that over the course of the administration, the focus would turn to the disabled and veterans. And the reason for that is simple, is that the United States is decreasing its troop presence in the Middle East and Afghanistan. We've got more veterans that are returning to the workforce in the United States, and many of those veterans that are returning to the workforce are injured. So the OFCCP has been a tool to try and help on employing these veterans. Let's go to the next slide. These are some statistics from the Bureau of Labor Statistics for 2012. In the population, the non-disabled population as a whole, the unemployment rate was 7.9%. In the population identified as disabled, and this does not count people who are not in the workforce. So if somebody is so disabled as to not be in the workforce, they would not be counted. We see a rate of 13.4%. On the veteran side, non-veterans, we see an unemployment rate of 7.9%, with the Gulf War II era veterans having a rate of 9.9%. And the discrepancy between veterans and non-veterans is even higher. We're seeing very high rates of unemployment among men in the ages of 18 to 24, who we would see as usually being in the workforce. Next slide, please. The new regulations were published in the Federal Register on September 24th of this year, which makes them become effective on March 24th of 2014. So it's important for everyone to get familiar with them and get ready for them now. The confusing aspect of it, everything goes into effect on March 24th except for the written affirmative action plan requirements. So if you have a current written affirmative action plan that's already in place on March 24th, 2014, then you won't need to update that plan to comply with these new requirements in terms of the affirmative action plan until your next plan year. So if your plan year starts after March 24th, 2014, you would need to do it for that year. So the example I give is if you have a plan year that runs from January 1st to December 31st, you won't need to incorporate these changes into your actual written plan until 2015. Next slide, please. So what are the big changes with the regulations? For the first time, we're seeing an annual hiring benchmark for protected veterans. We're also seeing a utilization goal for disabled individuals. Now, the utilization goal and the hiring benchmarks are different from the goals that we see in the executive order. The OFCCP regulations are very clear that this is not a rigid and inflexible quota that must be met. It says that in both the regulations under Section 503 and with respect to the veterans. So there's no automatic liability for failing to meet it. What we have with the benchmark is a yardstick, they say, to use to measure the success of your recruitment and outreach. And Mary Pivec's going to explain more about that benchmark as we get going. The utilization goal for the disabled individuals, that's going to be 7%, and that would apply to each job group if you're more than 100, or to the entire workforce if you're 100 or fewer. And Laura Windsor is going to talk more about those once we get going. One other new change is we've got an obligation to have a pre-offer invitation to self-identify as a protected veteran or an individual with a disability. That's in addition to the current obligation to have those post-offer invitations to self-identify. There are additional record-keeping requirements that Lynn Jacob will go over with you. The new regulations have a bunch of different new vocabulary, with updated definitions for both for the Section 503 as well as for the veterans regulations, and both Mary and Laura will go over theirs. The OFCCP has issued a new federal contract compliance manual. It's available on the internet. What that does is it goes through the current agency processes and procedures. It was very out of date until July 2013 when they put the new one up there. So hopefully it's a more accurate reflection of what the OFCCP is doing. And there have been many venues in which the OFCCP has made it clear to the public that they're inviting contractors to contact the OFCCP with questions during this time period when everybody's trying to come into compliance with the new regulations and understand them. So if you go to their website, there are ways that you can contact them with questions. If you're working with a compliance officer, that's somebody that you can ask questions about compliance with the new requirements as well. So today, we're going to give you, Laura Windsor will take over in just a minute and talk about the changes to the regulations for individuals with disabilities. And then Mary Pivec is going to talk about those changes related to protected veterans. Lynn Jacob is going to talk about the changes regarding outreach, compliance, and record keeping. And then Randy Thompson, who some of you may have worked with to discriminate against individuals because of their disability, but also requires contractors to take affirmative action in recruiting, training, hiring, and promotion of qualified individuals with disabilities. And so obviously the goal of the statute is to have contractors increase their hiring and recruiting and just providing opportunities for individuals with disabilities. So again, under the Rehabilitation Act, which has been in effect for 40 years, the general requirement is that contractors shall not discriminate because of an employee or an applicant's physical or mental disability, and shall take affirmative action to employ and advance in employment qualified individuals with disabilities, which applies at all levels of employment, from entry level to the most senior executive level position. And as we all remember, the Section 503 AAP policy statement that's in your affirmative action plan requires that contractors will recruit, hire, train, and promote persons in all job titles and ensure that all other personnel actions are administered without regard to disability, and ensure that all employment decisions are based only on valid job requirements. The affirmative action plan policy statement shall state that employees and applicants shall not be subjected to harassment, intimidation, threats, coercion, or discrimination because they've engaged in or may engage in protected activities. So that's all the background. And so one of the biggest changes in these new rules is really to help marry the definitions in the Rehabilitation Act with the recent amendments to the Americans with Disabilities Act. As I'm sure all of you remember, the ADA was amended in 2008. It's now the ADAAA or ADAAA. And one of the things that the OFCCP had observed was that, wow, with the new ADA definition of disability, we could actually, it's actually a much broader definition. And so what the OFCCP seeks to do by kind of adopting the definitions from the ADA amended is to broaden affirmative action coverage. And so what the new rule does is it adopts the ADA's definitions of disabilities, major life activities, physical or mental impairment, regarded as having such impairment, and terms such as substantially limits and mitigating measures. So I'm sure you all are completely familiar with the ADAAA, but it's just as a refresher, so now the definition that applies under the new affirmative action regulations are that a person is a person with a disability if they have a physical or mental impairment that substantially limits one or more major life activities. And so, as you should probably remember, this definition is huge. It is broad. It covers pretty much everything that you can imagine. My friends and I often joke that we're all probably qualify as having a disability. But one of the things that the EEOC had noted previously when it came out with the amendments to the ADA was that the changes, these definitional changes, could expand coverage of the ADA to over 1 million more Americans.
And so the OFCCP likes that. And so the OFCCP has determined that by using the ADAA's definitions, it will increase employment opportunities for disabled Americans. So as Sara mentioned in her introduction, one of the other huge changes to the final rule is a 7% utilization goal for individuals with disabilities. And a couple important points on that. The 7% goal is applied at each and every job group level, unless you're a small employer. So if you have 100 employees or less, the 7% goal is applied across the company as a whole. But so, for example, if you have 10 different job groups, not to belabor the point, but your 7% goal has to be for each of those job groups. So your senior, from your senior executives to your entry-level tradespeople. One of the things that was in the proposed rule, which did not make it into the final rule, is that in the proposed rule, there also would have been a 2% goal for, quote, severely disabled individuals across each job group. That did not make it into the final rule. The OFCCP also wants to make clear that the 7% utilization is a goal, not a quota. We'll see how that shakes out when they start auditing, but it's not a firm requirement. It's also not a ceiling, so you should aspire to more. It is intended to be a management tool that guides hiring, promotions, et cetera. Now, where that 7% came from was because the OFCCP estimates that 5.7% of the current civil labor force is disabled, and 7.42% of the civilian population as a whole is disabled, and so that's where they came up with the 7%. One other point about that, in the proposed rules, it was suggested that contractors should give, quote, preferential treatment to individuals with disabilities, meaning, if you've got, you could even apply on a point scale, you could give an individual with a disability more points towards hiring. A major component of the final rule is the self-identification requirements, and I will say that these are making a lot of people scratch their heads, because for individuals with disabilities, contractors must invite applicants and employees to self-identify as disabled at the pre-offer stage, the post-offer stage, and during employment. I think the pre-offer is probably going to be the newest development on this. At the pre-offer stage, the invitation shall be provided to each applicant when the applicant applies or is considered for employment. So you can include that invitation to self-identify with application materials, but they must be separate from the application. The internet applicant rule does continue to apply, so I know if you're receiving unsolicited resumes from people who do not meet the basic minimum requirements, they, just as before, do not need to be deemed an applicant. So, at the post-offer stage, that's pretty standard. It's at any time after the offer of employment. Then what gets also more interesting is at the employee stage. So contractors must invite employees to self-identify the first year after the implementation of the final regs and every 5 years thereafter. But one of the things that's important to note about that is that the OFCCP has stated that employees need not be surveyed, meaning you don't have, as an HR manager, you don't have to walk up to each of your employees and say, are you disabled, are you disabled, are you disabled? That can be done, again, through the same process that you would use for applicants and just merely use an invitation to self-identify. Responses must be kept confidential and separate from the personnel file. And the OFCCP is using a form, developing a form for contractors to use, which will be available on the OFCCP's website soon. So I'm sure many, I know I certainly thought about it when when the final regs came out, was kind of how does that work with the ADA's prohibition on employers making pre-offer job-related inquiries. And I've got a highlight there to an EEOC opinion letter, which basically says don't worry about it. So it's something that is that you're completely fine to do because you're required to do it under the federal affirmative action laws. And Lynn is going to touch on these issues, but I just wanted to make sure you had them in your slides. There's going to be new and different EO language that is required to be in all contracts and subcontracts, including the requirement that it be in bold print. And again, as you're used to, but it's going to be a different language, contractors are going to be required to state in solicitations and ads that they are equal opportunity employers. And then finally, as Lynn's going to discuss in more detail, you've got new data collection and analysis that you must do and record-keeping requirements. So with that, I'm going to turn it over to Mary Pivec, who's going to talk about the new veterans rules.
Well, thanks very much, Laura. Well, good afternoon, everybody. My task is to introduce you to the changes in the regulations dealing with the veterans, the Vietnam-era Veterans Adjustment Assistance Act, as amended several times, but most recently by the Jobs for Veterans Act of 2002. The regulations which we're going to be talking about today largely implement the requirements of Section 4212 of the Jobs for Veterans Act. Laura has already mentioned to you what the timeline for implementation is. These regulations for anti-discrimination purposes go into effect March 24, 2014, and then as Sara discussed, if you have a plan in place as of March 24, 2014, you can postpone implementation of the affirmative action requirements until the start of the new plan year, whichever is later. So moving on to the next slide. One of the major changes that we see in these regulations, apart from doing away with Part 250 of the regulations, is a new and broader definition of a protected veteran. As a term of art, protected veteran encompasses all of the subgroups below here, which I will be defining for you, that are now protected under the Jobs for Veterans Act, provided there is employer coverage as well, and we will be getting to that in a moment. But let's talk about these definitions of protected veterans, or the subcategories of protected veterans. By the way, you will find these definitions in the regulations at Appendix B to Part 6300. They are incorporated in the sample invitation to self-identify. A disabled veteran is one who is either a veteran of a U.S. military, ground, naval, or air service who is entitled to compensation, or who, but for the receipt of military retirement pay, would be entitled to compensation under laws administered by the Secretary of Veterans Affairs. Alternatively, a disabled veteran is a person who is discharged or released from active duty because of a service-connected disability. So that is a broader definition than that under the pre-Jobs for Veterans Act. A recently separated veteran has also been broadened. It used to be 1 year post-discharge. The recently separated veteran is now is protected for 3 years post-discharge. An active duty wartime or campaign badge veteran, for those of us who are do not live and breathe the Pentagon, refers to a veteran who served in active duty in the U.S. military, ground, naval, or air service during a war or a campaign or expedition for which a campaign badge has been authorized under the laws administered by DOD. You can, to the extent that you need to, you can access information as to what campaigns are covered, and this also includes the fourth bullet, dealing with Armed Forces Service Medal veterans. You can access that information at www.opm.gov/staffing portal VGMEDAL .ASP. There you will find 3 pages of wartime activities and campaign activities that would be covered by this. It is important, obviously, to know these categories and be able to identify them because they are incorporated in the new VETS 100A report, which will be the only report that you will be able to file for contracts entered into and modified on and after December 1st, 2003. And individuals who self-identify may be members of more than one of these groups, and every one of them in which they self-identify would be entitled to be counted on the VETS 100A report. Could we advance, please? So what happens to the older veterans who the pre-Jobs for Veterans Act veterans who were protected under Part 60-250 and were protected where the employer is a contractor with a contract of $25,000 or more entered into prior to December 1st, 2003 that has been unmodified since to up to $100,000 or more. And these categories, special disabled veterans, veterans of the Vietnam era, pre-JVA recently separated veterans, and other protected veterans, are eligible to file claims for discrimination under Part 60-300. And they remain protected, although DOL has told us that they suspect that this population is diminishing rapidly and is advancing toward retirement age, so it is far much... The likelihood of a claim being advanced by one of this class is growing smaller and smaller. But it's preserved, nevertheless, for those folks who are still members of the workforce. Now, with respect to the Jobs for Veterans Act, a contractor is covered where it has a single contract entered into on or after December 1st, 2003, or before December 1st, 2003, which has subsequently been modified, and the value of the contract is $100,000 or more, and the contractor has 50 or more employees. If those thresholds are met, then the employer is covered for purposes of compliance with both the anti-discrimination and affirmative action requirements of the Jobs for Veterans Act. Please advance. Sara mentioned that there is a mandatory hiring goal benchmark that has been set under these standards, and really the accommodation that was made for employers in the final rule is to adopt an 8% national standard. That information is going to be updated annually by the Bureau of Labor Statistics and reported on the OFCCP website. It is obviously a national statistic. It is not a Virginia statistic, where, as a whole, veterans represent a much larger portion of the workforce than many other states. It's one of the largest representations in the country for obvious reasons. Before, if an employer wanted to use the original test, it could do so, but there were 5 mandatory factors to be considered in setting the goal. These factors, for those who are not labor economists, proved very problematic, and the agency received overwhelmingly negative comments about having to use this test in setting individual aspirational goals for veterans hiring. As you can see here, you would have to have access to information on the state level, not just the national level, as to the veteran participation in the labor force, the number of veterans who received or applied for unemployment benefits in the last 4 quarters, plus the individual information that the contractor is compiling throughout the course of the year as part of the mandatory record-keeping requirements. The data is simply not available for those first 2 bulleted points. The Bureau of Labor Statistics does not provide it on a monthly basis. It provides it on an annual basis, published sometime in March of each year, but it is not broken down on a state level. And so it looks like, at least from a practical perspective, most covered contractors are going to have to use the national goal as their goal for a particular plan year. Could you advance, please? This is unemployment data. I think because we are so far behind here, I think I'm not going to belabor it, except to say that you can see that veterans unemployment in the South Atlantic, which includes Virginia, is 8.3%, and which is, I mean, it's a substantial rate, but I do not believe that Virginia's rate is anywhere near that 8.3%. I believe the latest figures for Virginia are probably in the range of 7.5%, but that figure is old, dating back to January of 2013. Could you advance, please? Some interesting statistics here as far as the distribution of the unemployment numbers. The highest levels of unemployment relate to veterans in the age group 18 to 24, but that is true of the general population as well. And this coincides with the Gulf Era II veterans group, which has a higher rate of unemployment. On the other hand, other veterans groups, from the Gulf Era I and the Vietnam era, the rate of employment and the level of unemployment compares favorably with the rest of the population. So catching up is probably going to mean hiring younger people and hiring those who are more recent veterans of the Gulf War era. Now, the mandatory job listing requirements. The Jobs for Veteran Act requires that you register with the State Employment Service, and in Virginia, the State Employment Service has written policies posted to the VEC website. All jobs now that, with the exception of the carve-out for the exception, the exempt categories of the Fair Labor Standards Act, must be placed on that listing. In Virginia, the default is 60 days, and the employer is required, under the Virginia rules, to post the wage range being offered for the vacancy. There's other information that has to be provided specifically in case of veterans, meaning the contact information for the employer representative at the facility where the hiring is to take place. Could you advance, please? Sara mentioned, or Laura mentioned before, that there was an obligation to include this language in your subcontracts. This is the new EEO contract clause, which would appear in your own contract and which flows down to subcontractors. Could we advance? Now, in terms of job advertisements, there was a lot of complaining because from employers who thought that the addition of the additional verbiage in the block in the middle on the second line down would exacerbate advertising costs. So we are now permitted, or employers have been given the option, to narrowly abbreviate that by saying we are an EEO, a minority, female, disabled veteran. I guess that's what that acronym stands for, and that will satisfy the notice requirements in job advertisements. Could you please advance? There are 3-year record-keeping requirements with respect to veterans, and this is going to be onerous. We'll talk about each of them in turn. I think Lynn is going to be talking about them in depth, but I'll do my best to at least do an overview here. Could you advance? At the pre-offer stage, and this is very important, as Laura mentioned, there is an obligation to provide notice to your applicants that of the classes of protected veterans. They actually have to be defined, and if you use the sample self-identification definitions, that would be a good place just to pick that language up. At the pre-offer stage, you also must tell them that they may have additional rights under USERA, which are not provided under the Jobs for Veterans Act. You also must offer this at the post-offer stage. Now, the reason why this is so important is that these regulations impose special reasonable accommodation requirements on behalf of protected veterans that do not apply in the case of disabled individuals. If a veteran, or if an individual identifies himself as a member of one of the protected veteran subclasses, and particularly identifies himself as a disabled veteran or a special disabled veteran, the regulations require the contractor to affirmatively provide a reasonable accommodation to applicants and employees. Indeed, a contractor has to seek the advice of a disabled veteran as to the reasonable accommodation that he or she will need in order to perform the essential functions of the job. In other words, you have to assume the need for accommodation even though there hasn't been a request for one. And that is the difference with for those who are not between disabled and non-disabled, between disabled veterans and the disabled population generally. There are recommended non-mandatory procedures for complying with the record-keeping obligations, and those are found in Part C or Appendix C of the regulations, Part 60-300. Although the OFCCP says you don't have to do these, I think in order to comply with the record-keeping requirements, you will find yourself inevitably setting up systems that will enable you to capture this information for the protected population in order to be able to complete the VETS 100A report and to prepare for an audit for compliance with this part of the regulations. Could you advance to the next slide? You will have this deck is being given to all who are participating today, so I will not bother to read it since my time is almost up. But please do remember that if you obtain information with respect to disability or medical condition, it has to be maintained separately and treated as a confidential medical record. Please advance. Okay, so the heavy hand of the law says we may not be coming after you if you don't meet this aspirational goal of an 8% hiring objective or aspiration, but God help you if you don't have the records that we say you need, because under those circumstances there will be heavy fines and penalties, and we will assume that you are non-compliant because you have failed to comply with the record-keeping requirements. So I'll turn it over now to Lynn, and she will take you through greater particulars as to what you have to do to comply.
Really do have limited time here, and a lot of these topics have been pointed out already, so I am going to just race right through this here, just to give you the lookout that you need to watch out for these things. And let's be candid. In the past, there have been no matrices. There's been no money involved. All we've had to do is get the right verbiage on our plans and hand it in. And if you were audited, the OFCCP did not focus on it. And so there's a lot of requirements that are already in existence that we tend not to focus on and may even have forgotten that we have. We've always had a job posting requirement, and it has not significantly changed. Mary went through some of the requirements here, so I don't have to go through them again. But just remember, you need to post all of your job openings unless it's for a job that would fall into a non-exempt executive senior management type of position. The new thing now, however, is that to the extent you now have to inform the employment service delivery system that they should give a priority referral to protected veterans. That's a new one. If you're using a job search company to locate your applicants, then it's fine just to list the vacancies with that private agency as long as they make sure that they tell the employment search delivery system about those vacancies. So you can delegate the authority on all of that. As mentioned, we need to change the tagline on our advertisements and internal postings. Make sure that instead of saying EEO, AA, employer, we're now putting the new language in there. We're going to need to update our EEO clause in our contracts and purchase orders. It can refer to the Code of Federal Regs, instead of incorporating all the verbiage except for now, the regs are slightly changed because they've done away with the 60-250 having to do with the old Vietnam vets and contracts. And so there's just going to be little buzz things that the government will look for to say, have you updated or not? And that would be one if you use the wrong code section. And then the other is that in bold you have to put new language in there. You don't have to make the language up. You got to quote it verbatim from what the government has given to us. We need to revise our letters to our subcontractors. We need to provide written notification of our affirmative action policy and request their assistance. And that is going to apply to all subcontracting vendors as well. It's nothing new. It is required that we have mandatory outreach, but the government is just saying you got to do some of these things. You don't have to do all of them. You can pick and choose. And there's a list that you can go through to say, well, I'm going to do this, and well, I'm going to do that. For instance, you can have you can liaison with local veterans groups, or you can work with the Department of Veterans Affairs, or you can liaison with organizations that are listed in an employer resource section of the National Resource Directory. There's a whole bunch of things. It's not that they're leaving you out there with how the heck am I going to reach my benchmarks. They give you options and you can choose any of them. We have to slightly revise our EEO policy statement. There's a whole list of things that need to be in it, and they pretty much speak for themselves. It's nothing difficult. You just have to go through the process. And I think we've got the wrong slide. You've got to go forward. There we go. Are you going forward? All right, yeah. So we have to modify applications. Can you move forward? Thank you. Keep going. Modify applications. There we go. There's a big focus on the electronic process, notification process through these regs, which includes the, not the requirement, but the suggestion that if that you put your applications online. And right now the OFCCP is asking whether you, to see a copy of it, or they're looking on site to see whether you have a little phrase that says, if to the extent you're disabled or you're unable to use this online tool to search, then you should contact the company and they give a phone number. If you're not doing that already, you should be doing it as of now. As we've talked about before, your application is going to be readily clear whether you're complying or not, because it's going to have totally new information in regard to that request to self-identify, in which you're going to be asking whether people would choose to identify themselves as disabled or a protected vet. There are 3 times now when you're going to have to invite people to self-identify. One is on the application, or it's a tear-off sheet. It's not really part of the application, but it's got to be at the same time that you are, the person is applying or you're considering them for employment. So sometimes employers probably shouldn't be, but are kind of making their decision, and then they're getting people to apply. It's at the time that you're considering, if that comes first, that you got to ask them about this. So you've got to do the pre-hire, and then between the time they're made the offer and the time that they start working, you have to ask them again. It's a slightly different form. It goes into the different types of veterans, et cetera, that they may be. And it also invites them to tell the contractor how you could accommodate them. And then a third time is every 5 years. If you're a brand new contractor, you have to do it right away. But other than that, it's every 5 years. They had talked about 1 year. And then you have to remind people, excuse me, of their rights sometime in the interim between that 1st and 5th year. So I'd say put it on your calendar every 2.5, 3 years. Remind people to self-identify, and then do a blanket distribution throughout your workforce, asking people to self-identify. Remember, you can't coerce people into telling you. You just have to give them the opportunity. keep going. Let's go through, let's go past electric postings and go to training on the, there has been a requirement all along under these regs that one train their personnel that are involved in recruitment, screening, selection, promotions, discipline. I can tell you right now that if you're being audited now, they're going to ask to see training records. So please make sure you get that accomplished as soon as possible. There are new data collection requirements. There's a 3-year requirement, so you need to be keeping all of the information that you receive from your request to self-identify. To the extent they have identified themselves as protected veterans or disabled in the application process, you need to keep that. Here's the list of what you need to keep. You do have to revise your affirmative action plan, and we don't have time to go through all the verbiage differences. It's the exact same requirements that you had before. You had to have a policy statement, review on personnel process, physical and mental qualifications, reasonable accommodations, harassment, external dissemination of policy, internal dissemination of policy, audit reporting, responsibility, and training. It's the same, but what needs to be in there has changed a little bit, not a whole bunch. Let's skip the next couple of slides here on the reasonable accommodation. That's not a lot of new things. It's what we've been doing all along under the ADA on the most part. But when you get to this revised text of disabled, and I'm going to stop very soon here, we have always recommended that when you have an application, you have a line and they say what they are applying for, and that's the only job that you consider them for in your hiring process. But no, let's not treat everybody the same. Now what they are suggesting is, to the extent, and this is not a requirement but it's recommended, to the extent a protected veteran is applying, you should be considering other vacancies even if they have not put on their application that that's the one that they are applying for. There are a lot of personnel policies, procedures that they recommend that are not required. They do require you to review how you've done every year. And if there's a problem, then you're supposed to find other ways to accomplish your objectives and write all of that down, and all of that is going to be discoverable. You are now going to keep 3 personnel, you can keep 3 types of plans. You're going to keep the personnel file, the medical file, and then the disclosure as to Vietnam vet status. With that, I'm turning it over to Randy.
I just wanted to go over real quickly that the nuts and the bolts of putting the plan together really are not going to change. We're still going to need 2 separate, distinct sets of employee data. The snapshot date, or the close of business of your plan year to start your next plan year is going to remain the same with the mandatory data on race and gender and job title and all that good information. But on March 24th, that's going to now have to include veterans and individuals with disabilities. This is still going to be your plan for the new plan year, but now we're going to be analyzing whether or not we're meeting our goals in job groups for individuals with disabilities, much like we would for race and gender that we're doing now. Also, the personnel activity data for hires, terminations, applicants, and promotions, that data for the preceding 12-month period from the start of your plan year, we're still going to need. We're still going to need that mandatory data on race, gender, job title, but that is also going to need to include whether or not the individual is identified as a veteran or an individual with disability going forward. One thing I do want to emphasize that I've seen over the years is that the data must be consistent. A terminated individual should not show up on your snapshot date. An individual who is deemed hired on your hire log must be on your applicant log. Race and gender information and job title on your hire log should match. If you hire Randy Thompson as a white male on your hire log, I should not show up as a white female on the applicant log, although I know people who would not argue that point. Lastly, I just wanted to go through some points of what the OFCCP has been asking for recently in audits. I hope you're not one of the unfortunate contractors that has to go through with this in the near future, but they've resurrected some issues that they've not concentrated on for many years. The first one is they've been requesting copies of your prior year plan. Most notably, a copy of your job group analysis and summary. They have not asked for that recently at all. Secondly, they are requesting data on employee requests for leaves of absence. They want to know the reason for the leave, what the decision was on the granting of the leave, the length of time, the date the individual employee returned to work, and also whether or not that employee was a veteran, i.e. were they asking for time off for National Guard service, etc. Also, they've been asking for data on requests for accommodation looking back a preceding 24-month period. And also they're asking what type of accommodation was requested, what was the contractor's decision on the accommodation, the length of time, etc. You should also be prepared to be able to articulate, outline your hiring procedures. I would go over to make sure that they're consistent, that they have been consistent during the relevant time period, and that your disposition codes are being used, especially for your applicant and hire data. The OFCCP has always been interested in your compensation, but they've now become even more interested in how overtime is being distributed. Is it being distributed fairly over the race and gender categories? And also bonuses, if they're giving out, how have you been giving out bonuses over the time period? And finally, the one issue that trips up most contractors during an audit is the positive outreach. I know Lynn touched on some subjects for positive outreach, but send your community outreach letters out. I mean, all this information needs to be sent out and shown that you've been doing it for the preceding 12-month period. And a lot of times you get into an audit situation and you find that you don't have copies of the things that you said you did, and that does not help with the OFCCP. So send your community outreach letters out. Community colleges are always the best form. Keep evidence of that you've attended job fairs, that you've reached out to veterans and disabled organizations, as Lynn has pointed out. And also keep evidence that you've posted your open positions with the VEC or other applicable state agency, so that when the audit time comes around, you'll be able to show that, because the OFCCP will know already, because they will probably have already called the VEC. And that's all I have.
Thank you, Randy. Now, if you have not already submitted questions via our chat feature, please do so now. And I'm going to reach out to my colleague, Paul, and find out if we've got any questions. And if, Paul, you could please unmute your phone and then direct those questions to whomever might be the appropriate answer.
Great. Thanks, Patty. This is Paul Reimel. I'm a business development manager with Williams Mullen. We do have, I think, time and at least 2 questions. So I'll start that off. The first one. If an employee does not self-identify as disabled, can I count them as disabled when they have asked for an accommodation before, or I'm aware of a disability they have? If one of the panelists might want to speak to that, please.
Yeah, this is Laura, and I think the issue is basically, you know, you've got reasonable notice because they've asked for an accommodation that they consider themselves to be an individual with a disability. So yes, in your record-keeping processes, you should certainly treat them as an individual with a disability.
The regs actually say if they self-identified or you have other reason to know.
Okay, great. And then I think we have time for one more question. Under the amended ADA, we have been told that almost any impairment is considered a disability. Would the same standard apply for employees to count as part of the 7%?
Absolutely. I mean, that's part of what the OFCCP was going for, was to marry its regulations up with the ADAA. And so, yeah, that broad definition will absolutely apply. So when you've got someone who is, who is claiming that they are disabled by virtue of, diabetes, for example, then yes, they would be treated as disabled for affirmative action purposes.
Great, thank you. All right, one more. Go ahead.
One more? We have one more question?
One more just came in. What are the requirements for job postings in another state? Do we still need to post in VEC?
The requirement is that you post with the applicable state employment agency in which the position resides. So if the position does not reside in Virginia, but resides in Indiana, you would have to find the employment agency in Indiana.
Okay, good.
Great. Thanks, Randy. I'll turn it back to Patty.
Great. Well, I want to thank everyone today, our webinar panelists for sharing their experience, and all of our guests for their time today. And please contact any of our panelists if you have additional questions. Following today's webcast, we will be sending a link to this presentation along with some to-do items that you might want to consider and supporting materials. We hope you will join us for future events and enjoy your day.